How does the long arm statute work in New York? To find out, you have to read New York versus Value. It's only 27 pages. Don't have time for that? I got you covered. This is TLDR, Too Long Didn't Read. Court of Appeals cases in 5 minutes or less. This is the case of the State of New York versus Value. It can be found at 2023 New York Slip Opinion 00801, or a copy of the decision is linked in the description. And it's published by the Court of Appeals on February 14th, 2023. It's a civil case. It's a civil procedure case about CPLR 302, the long arm statute. The issue in this case is what kind of contacts and actions on the part of a defendant subjected to long arm jurisdiction in the state of New York. To understand this case, you have to understand that one of the important ingredients to have a case in New York is the court has to have subject matter jurisdiction and personal jurisdiction. Personal jurisdiction meaning that it has sufficient control over the defendant that if it issues a ruling, if it issues a decision, or it orders relief, it can be comfortable or confident that the defendant will be responsible for complying with that order. If a person is in New York, it's easy. They live in New York, they're subject to personal jurisdiction. But if it's an out-of-state company or an out-of-state person, you have to somehow get personal jurisdiction over them. And the general rule that you have to understand here is that CPLR 302 says that a court can exercise personal jurisdiction over a non-domiciliary, someone who's not in New York State, if they transact any business within the state of New York or contract anywhere to supply goods or services in the state. That's CPLR 302 sub 1. And what that means is that the defendant has to take voluntary actions, volitional acts, affirmative acts to avail itself of New York State's jurisdiction, has to take certain actions. It can't just be grabbed for actions that took place somewhere else, or if it had no intent or understanding to be pulled into New York courts, it's not fair. So what are the facts in this case? Value is a Delaware corporation headquartered in Michigan that makes drones. They make flying drones, UAVs. And in 2003, Value's CEO contacted Dr. Small about using UAVs to transport lab samples. Fine. Nothing happens, but 2 years later, Dr. Small is now a professor at SUNY Stony Brook, a New York university in Suffolk County. And Dr. Small then calls back to Value and says, "Hey, I know we talked a couple of years ago. I want to talk more about this idea about buying drones to send to rural parts of the world where they can transport lab samples." They talk by email, they talk by telephone, they have a lot of different, they have a lot of communication over those couple of years, and they apply for a grant. Value applies for a grant to the USAID, which is the United States Agency for International Development, to get money to do this project where they buy UAVs and send them to Madagascar to transport lab samples. And in that grant proposal, Value describes Stony Brook as a partner and describes Dr. Small as a key member of the team. Ultimately, they get the grant, they buy the UAVs, they send them to Madagascar, they don't work right. There's a dispute about this. Stony Brook sends it back to Michigan, and Value never gives them money or gives a refund or gives a replacement. Breach of contract. Stony Brook sues Value in New York State, and Value moves to dismiss, saying no personal jurisdiction. I'm not from New York, and we sent it directly from Michigan factory to Madagascar. You have no jurisdiction over me. The trial court agrees and dismisses the case. The appellate division agrees and affirms them. It goes to the Court of Appeals, and they say there's a majority and a dissent here. The majority says there was clear intent on the part of Value to provide these services, and they knew they were getting involved with Stony Brook. They called them. They go through the whole recitation of facts we talked about, and they say that those actions, in particular, the fact that while they were disputing about this, the Value CEO went to New York to talk about further business propositions, means that Value was engaging in business in New York and expected to, and it subjected itself to New York's jurisdiction. Specifically, they talk about how there has to be the Court of Appeals, so there has to be an articulable nexus and substantial relationship between the defendant's activities and the cause of action. And here there was. And they also say that the exercise of jurisdiction has to comply with due process, has to be fair. And here they say it was. Obviously, there's a dissent here by Judge Rivera, and she says, no, the trial court was right. The appellate division was right. Here, Dr. Small initiated the business. He contacted Vayu from New York, and all Vayu did was communicate via email and telephone and send it to Madagascar. There was no expectation that Vayu would be subject to New York's jurisdiction. And that's the case of New York versus Vayu. Too long, didn't read. Court of Appeals. If you like what you just saw and want to see more just like it, please hit like or subscribe to let me know.